Ready, guys? I'd like to call this study session of the Board of Adjustment to order. I will now call on Deputy Director Heather Vidlock to present on behalf of staff.
Welcome, Board of Adjustment. We appreciate your extra time this evening. We have worked together, staff and the city attorney, to create the structure for this work session. What we hope to accomplish in going through the slides that we will present to you in a minute is to refresh your memory, or if you don't recall, make sure that you understand the importance of how to run a quasi-judicial public hearing, what ex parte communication is, proper hearing protocol, and then at the end, we'll talk about some kind of practical experiences and things that you can do as board members. Our goal is to have the group become a little more cohesive and a little more procedurally accurate in terms of following procedures. So I'm going to turn it over to Quali Farbs, our Senior Assistant City Attorney, who represents or who supports the Board of Adjustment now, and she'll go through her slides as soon as we get those up. You will have a chance, if you have questions as we go through the slides, please raise your hand so that we can address that at the time, rather than, you don't have to save all your questions till the end.
Okay, good evening, everyone. I'm Quali Farbs, Senior Assistant City Attorney. It's a pleasure to be with you this evening. And I just sent the slides to Frank. We'll get started. I'll just talk about a little bit about the agenda, which will pop up on the screen here for you in just a moment. We're going to cover your role in pre-hearing preparation, and then we'll do an overview of the quasi-judicial role, and then your role during the hearing, things that you should consider when deliberating, and then most importantly, at the very end, we'll talk about court challenges to your decision, which is why we're having this conversation. We want to make sure that as you're preparing for the hearing and you're conducting the hearing and you're having deliberations, you're doing all of that in a way that creates a record that is tight, so that you are not subject to challenge and your decision is not going to be overturned. And we are here, I am here, and Heather and Mike and Dalton and Frank, we're all here to help you navigate the hearing in a way that creates a really strong record. So I want to start off by just saying that. You good? Nope.
is ready.
Are you on the network? It says that you are. Try that one. For some reason, I'm not getting it.
It should.
Don't you have the PDF, Frank?
I have the PDF, but we're thinking it's better to use the PowerPoint.
Okay, well, if we can't get the PowerPoint, we can just use the PDF.
Technical difficulties, we're working on it. Thanks for your patience.
There's no attachment. Has it gone to bottom?
Let's just open the PDF. That'll work.
It's so strange. Okay.
Just a quick question. Is this being broadcasted? Did I cut you off, Frank, from your intro, or will we wait until the official meeting?
No, after the study session, then
Okay.
we'll go into the regular session.
Okay, I just want to make sure. Thank you. Sorry.
All right, I think you can go to so here's our agenda, which we just covered. I think you can go to the next slide. All right, this slide covers your role as a member of the Board of Adjustment. You are essentially functioning as a judge. And that is because the matters that come before you as the Board of Adjustment are subject to due process because they're related to property interests. And they're subject to due process. Which we've listed here on the slide. No person shall be deprived of life, liberty, or property without due process of law. And so it's your duty to make sure that you are providing each of the applicants with due process, which means that like any other matter before a judge, before, during, and after the hearing, you need to be acting in a manner that is fair, unbiased, and impartial. That means that you should not have any ex parte communications or be doing any advocacy before the hearing. And that you're considering and you're making a determination based on the facts and evidence that are presented to you during the hearing and applying those facts to the law. In this case, it's the approval criteria. And you all should, please feel free
Let's
to.
just pause there on ex parte communication.
Yep, and we're.
Oh, we have another slide.
We have another slide
Okay,
that's gonna
never
go
mind.
into that a little bit more.
Sorry.
But I do also want to say, if you all have questions, please feel free to ask them as we go. I think saving them to the end might be a little cumbersome. So please stop me if you have questions. And then I think that quasi-judicial is
Okay.
in the next couple of slides. But Heather and Mike, if there's something that you would like to say, please feel free to chime in. These are just a few of the things that you all are well aware of, the kinds of things that will come before you. These are all matters that are quasi-judicial, and then we just made a little note here that annexations are different. Those don't come before you, those are legislative. We'll move on to the next slide here. All right, so here are some of the things that you might consider as you're preparing for the hearing. So you get a packet. We recommend that you think about what is coming before you from a judicial framed mindset, right? You want to be neutral when you're looking at the items that are in your packet. Be mindful of the kinds of comments that you're making. Don't go looking for outside information other than what has been presented to you. This is certainly petition season. I was at a festival over the weekend and was stopped several times and asked to sign petitions. Please don't sign petitions that relate to matters that might be coming before you. And then there's the ex parte communication. Please avoid those. Your decision should be based on the evidence that's presented before you and the record that's created during the hearing.
Ms. Forbes,
Yes, yes,
I have a question.
yes.
So you mentioned don't go looking for information, which I understand. But I'm just kind of curious, like, if we had a question while we're reviewing our packet, if like a definition or something that's in the code, we can go look at that because that's what we're being judged upon.
That is a great question, and I think if you have that kind of question, that's what Heather and Mike are here for. So you should feel free to send them an email and ask that question.
Yes, yeah, great question. Please send us an email. If we cannot answer that over email, we will make sure and make it part of the public hearing, but that will help the public hearing process move along smoothly.
Any other questions before I keep going?
Just want to make sure everybody knows, because our next bullet point there was about ex parte communication. What ex parte communication means is that you're having conversations or communication with anyone outside of the hearing. Your fellow board members, a neighbor of the property, your spouse. You can't have any communication outside of the public hearing regarding that case, or it's considered in Colorado and in other places, it's called ex parte communication. So just want to make sure you understand what that phrase means.
And there's a little more information about ex parte communications on this slide. And part of the reason we're spending some time on this is that this is the thing that most often will cause one of your decisions to be overturned. This happens unintentionally, I think, quite frequently. And so this is the one thing that we want to make sure that you walk away from this work session, this study session, with a refresher around this issue in mind. This is most frequently the thing that could cause one of your decisions to be overturned. And so I also just want to note for you all that we've added into our regular meetings, we'll do a little reminder before the hearing starts around this issue. If you've had ex parte communications or you don't think you can be impartial, we're going to ask you about that before the hearing starts. So if you've had ex parte communications, but you think you can be impartial, we're going to ask you about that. And if you would please make sure to disclose that. If you don't think you're going to be able to remain impartial, we would also ask for you to disclose that and then recuse yourself. Because that is also something that could cause your decision to be overturned if there were to be a 106 motion filed against the city as after one of your, a decision is made by the board. So I guess I'll just pause there and see if you all have any questions about that. Yes.
So these would be conversations prior to a hearing, after it's been deliberated and voted, would those you would still want to avoid those conversations after the fact?
I would say yes, but we are most concerned about the ones that are happening prior to the hearing. Because the decision that the board makes needs to be based on the evidence and the discussion that is presented at the hearing. Just like in a trial, right, the judge makes a decision based on the evidence that's presented and the motions that have been made by the lawyers in the courtroom.
Thank you.
Yeah. Any other questions before we move to the next slide? No? Okay. All right, here are just some suggestions in terms of preparation for you all. The staff report is a really great place to start. Given the discussion that I was here for last month, you all I observed that you do a really great job of paying attention to that. It's a really great place to start in terms of your questions. And considerations for your discussion. Let's see, I'm not gonna read the slide to you, you all can read. But these are some ideas in terms of like the kinds of questions you might come to the board meeting with, and or things that you might reach out to Heather and Mike about. And I don't know, Heather and Mike, do you have anything you want to add?
I just wanted to add that when we are preparing the staff report, we're trying our best to give you the background, the history, make sure you understand exactly what the request is. When it comes to the recommendation that staff provides, that is not just the case planner in a vacuum. We bring variances to our development review team, which is a comprehensive team of people within the city and our partner agencies, like the water department, the fire department. We get input from all of those people on variances. And when it comes to making a decision of whether we are going to support or not support a variance, that's made collectively in our planning division. It's never just up to the case planner that's presenting to you that night.
Okay, the other thing that you should be aware of is that if there is a Rule 106 challenge to your decision, the court isn't going to relitigate what happened here, the hearing and the evidence that's presented. They're going to rely on the evidence that's presented here tonight and each of your board meetings, and your deliberations in terms of whether or not they're going to rely on you in terms of the procedure that you followed, the evidence you considered, and the rationale and the deliberations that you have for your decision. And so it's important that as you are moving through the hearing process and your deliberations, that you are following the procedure and doing it in a way that is consistent with your rules and requirements, and that we haven't strayed outside of and included ex parte communications or things that are outside of the boundary of what's appropriate for this board to have looked at. But we also want to make sure that you get all the information that you need as a body to make an informed decision.
And Quali, if I may, always a good rule of thumb, and I think this board is very good about doing it. In your deliberations, mention the review criteria specifically, and that always helps. Thank you.
Yep, that's a great segue to our next slide, Mike.
Ms. Forbes.
Read my mind. Oh, does somebody have a question? Yeah.
So, if it is at the appeals court and the judge is reviewing, maybe I missed it, but, they're reviewing like the transcript and the video of our deliberation, making sure that they're not deliberating on whether we are, like, how we got to that decision was right. It's, did we follow procedure?
Yes,
Clarify that. It's
Yeah.
procedure, not
Yes.
how we came up to that conclusion.
that's right. And we have a slide at the very, very end where I will get, you're ahead of me a little bit. But I will get to that at the very end. Yeah. Here we go. Yep. Okay, so here are just some other thoughts for your consideration in terms of preparing before the hearing. Good questions to ask, and then some that might lead you all on towards a conversation that might take you a little bit off course. And so we've just given you some examples here of questions that we think are great, questions that might lead you astray or a little bit down a rabbit hole. I don't know if you all have any questions about these. The question here about have there been other variances for example, for this kind of height of fence? Because a variance is based on a particular circumstance, asking if there have been other variances for a particular kind of applicant's request is a little bit like each variance is unique. And so asking if there have been others in the past can kind of lead you astray because it's asking sort of like to compare apples and oranges. So that, for example, that's an example of why that question is there.
I have a quick question. Does it not say somewhere in our review, one of the criteria is that this is consistent with the neighborhood and neighboring lots, that the height of a 8-foot fence would be consistent with other 8-foot fences? Isn't that not one of the criteria of the variance?
So what Ms. Farbs was describing is that variances are not precedent-setting.
Oh, I
In
understand.
other words,
I'm
each
just,
variance stands on its own because it has its own standing.
And-
When it comes to the question related to the criteria, you're being asked, how does this impact the surrounding neighborhood? Does this variance have an impact? It's not the same question of have other variances been granted. Those are two separate things.
okay. What is the impact of the variance we're looking at? So if there's an 8-foot fence in a 6-foot fence neighborhood, there's a huge impact? Is that where the logic goes there, or?
So I think it's an interesting question to ask.
Well, it's part of our review criteria.
Right, and I think you can ask about the neighborhood if we know of any other 8-foot fences in the neighborhood, but you may not want to tie it to another variance request. If there's a subtle distinction.
I was thinking more of a macro level, community level, not a micro. I wasn't trying to tie it to another lot, but
Yeah,
it has to be similar within the community, as I understand.
yeah.
And what I sit here and read, when they say, okay, part of the review criteria is that it is in the neighborhood or within the community. It's normal and looks like it should be there.
Yeah, you can ask, and these are kind of guidelines. I think what we were trying to pose with this question is if you're asking about other variances granted, that may lead you astray as far as that, okay, this is an individual request. But maybe a perfectly valid question is, for staff, is are we aware of other 8-foot fences in the neighborhood?
Okay,
And
so
that is
don't
tied
ask
to
if-
one of your review criteria.
An inappropriate question going off this would be, are there any other variances in the neighborhood that were approved with 8-foot fences rather than, and a better question would be, are there 8-foot fences in the neighborhood?
Yeah, is staff aware of that?
Okay.
Great distinction, I think.
Okay.
To follow up on that, because I had a similar question, and so I just, from my recollection, so I thought height variances had different criteria than a regular variance criteria. Am I correct, or I could?
Yeah, they're slightly different.
Okay, I just want to make sure, because you're given a height variance criteria, and then we have standard variance. So like so in a regular approval, we have like A1, it talks about, it's like combining two different things. It's like, from how I read it, is property, including dimensions, topography, or other extraordinary situations, which is like to the property, which is quite typical, and I understand that. But then it goes on where create a situation where the strict enforcement of the standards in this land development code will deprive the property privileges generally enjoyed by a property of the same classification in the same zoning district. And so I can see how they're to the physical characteristic, but that other extraordinary situation, which is not related to property, is kind of how I'm seeing it. So it, like, if we haven't made an enforcement action, because we've had certain cases that come up before us because it's an enforcement action, but we haven't treated, like, we had a case last year that staff had identified there were a number of other properties. They weren't treated a similar fashion, and so they didn't get variance requests, and but this one applicant did. I'm just kind of curious, like, it's not related to the property, it's related to how we are treating, which is to the making sure that everyone is following the rules, which you highlighted at the top, Ms. Forbes, which so I'm just kind of curious, from your legal opinion, how are we supposed to understand from a legal perspective that interpretation?
I think the point that I was trying to make is that each request should stand on its own, right? And you should take each application and apply it to the criteria based on its particular circumstances. I don't know if that helps to answer your question.
Mr. Frywaite, one of the things, and Mike Sutherland, our director, oversees code enforcement, so he can add to this. But when our code enforcement team goes out into a neighborhood, they are not selectively picking on individual people. They're looking globally at that neighborhood to see if there are structures. Sometimes they find structures that were built without getting a permit. And if things didn't have a permit, then sometimes they don't meet the code, and therefore they end up at the Board of Adjustment. But it's really not up to the board to cipher through, is the city being fair in our code enforcement actions? That's really out of your scope. Is there anything you want to add to that, Mike?
Well, my question is, it's the strict enforcement, and so I'm just I just want to clarify what is that legal understanding of how am I supposed to, because it's not related to the dimension of topography, it's would remove a privilege. And so the reason why I ask it, and I think that's what Mr. Vladkis was getting to, is, like, I understand that perspective, but the criteria is not on a dimensional or something to do with the property, where most of it is the extraordinary part. And so that, and mind you, we are the ones that are judging this, and that is what we are asked for. And the way I'm reading this, it's, well, it opens that door, or at least I can see how it can open the door of, no, this does create a opening because we are not upholding the rules fairly. And if we do see it in a presentation, like we notice it, it is our obligation to, ask the question. And so I'm just kind of curious, I'm like, that's how I'm seeing it, and that's why I'm more curious on the legal opinion of, what does that mean?
Well, I think my suggestion would be if you have that question for each applicant or in each application, based on the analysis that staff presents to you, that's a good question to ask them, because they're going to give you a recommendation. And you can ask them about how they came to that finding, right? And then I think there is a judgment call that the board gets to make, and you as a board member will get to make, based on their recommendation.
Are you looking for a definition of like extraordinary circumstance? It comes up and we need to find out, what is an extraordinary circumstance?
Yeah.
Is that the road you're?
Yeah, thank you.
So that opens the door for you to ask, is this an extraordinary circumstance?
And
I think we had one case where COVID played a part, and
Yep.
was that considered an extraordinary circumstance? So I'm just trying to follow up on Member Fryway there.
Yes, and I think that's a question that you can certainly, that ties to the approval criteria. And I think that's an appropriate question to ask during staff's presentation, and maybe to be part of your deliberation once the presentations are complete. Thank you. Yep.
If I could just add, sorry.
No, go ahead, I'll go after you.
If I could just add to that, we're talking about hardships, right? And one of the classic examples of a hardship is a pie-shaped lot. The owner may have purchased the pie-shaped lot, but it's a circumstance that may create variances in the future for owners of pie-shaped lots. And our review criteria are written in such a way that you're able to interpret different circumstances. So as Ms. Farbs was saying, a great question to ask, what are the extraordinary conditions that lead to your recommendation, staff? But yeah, excellent line of questioning.
Yes, I was going to bring up last month, we had before the hearing was kind of an unusual situation. Should we have been part of that play of that continuing it based on the signage not being in place? Is that something that the city should have taken care of beforehand? So we, as Board of Adjustment, should not have been part of that decision to make those adjustments. That should have happened prior to us, prior to us receiving the information to open up this case, because then that put us in a really peculiar situation.
Yes, thanks for asking that. We are going to do a better job of making sure that all the notification information is available to you at the hearing. If you have a question about that, best to ask staff if there's a issue. But once notification has been deemed complete,
City attorney, yeah.
Yeah, right. So we are working with the city attorney's office on that. Is notification complete according to the code? We can advise you that we think the notification, or we have determined that the notification is complete, and then it's a little bit, it may lead you astray to talk about it at the meeting, but we've both got work to do on that regard. Not just this has been an issue with not just the Zoning Board of Adjustment, but also other boards and commissions. So we're working on solutions to that, and do appreciate the situation that you've been put in that regard, and other boards. So we're working to cure that right now.
Right, because I just want to make it clear, because we're in this arena, and yes, each case is different. They stand on their own merit. But when you see signage out on the road, it has to be correct too. And I know there's, just put clarity around this, there was a recent signage that was up and had a QR code. Well, people are frustrated because the QR code didn't work. And is that our job to make sure that that's done correctly? Because it's gonna come before us, right? So how does that play into this quasi situation?
So when it comes, go ahead, Paul. What were you gonna say?
I was just going to say, I think that's part of the ex parte communication piece, is that it's important for staff in the city attorney's office to be working to make sure that things are posted appropriately and correctly. But this body should be receiving evidence as part of the hearing. And if it's okay to do like a drive-by to kind of get familiar with the property, but anything in addition to that is considered ex parte communication, right? So then we start into a place where it starts to look like the board's deliberation is maybe not as impartial as it needs to be. And so I think those are those kinds of notice and posting issues are things that staff and city attorney's office should be addressing. And we would like to take that out of your purview and put it squarely on this side of the dais.
Okay, because if we're talking based on evidence before us,
Yep.
I don't think anybody should be going by any property. I think it should just be what's in front of you when you come to a hearing,
Your rules say that you can do a cursory drive-by.
really.
Yep, that's what it says in your rules, but anything more than that, I think, starts to become a challenge in terms of your ability to act as an impartial body.
All right, well, I appreciate that clarification.
Yep.
And that's more for, because we live here and we'll organically drive by it, whether we know.
Right. I thought that was kind of a funny thing to put in there too. But, that's what it says. And so, yeah, you all live here, you know your city. Yes.
I think in my experience with Board of Adjustment, the risk of stopping your car, getting out of your car, walking around the property is that a neighbor, the applicant, someone could come up to you and approach you, and then it's very difficult to say, I can't talk to you because I'm a board member. So the nomenclature of drive-by is intentional, so that you're not getting out of your vehicle, you're not approached by anybody, and you don't risk putting yourself into a situation where you could have ex parte communication.
All right, thank you.
And I guess to beat a dead horse, so the notification requirements are kind of to the best of our ability as staff, and broken links and that type of thing may not necessarily disrupt, but they could cause concerns from citizens who are trying to get more information. So if you notice anything like that, there are, if a sign falls down, for example, the rules indicate that they've got a certain amount of time to get a sign back up. And so if you notice something like that, notify staff, and we can notify the applicant and make sure that the sign gets up in the appropriate amount of time. If there's a link that's broken that you notice, tough to do on a drive-through, but if you notice anything like that or hear of anything like that, let us know and we can try and correct that, and make sure that links are working properly, that type of thing. So
Thank you.
thanks for your indulgence there.
Sure.
Mr. Leffel, did you have a question?
Probably won't be appreciated. So you're doing your cursory drive-by, as I have done to every property and every case that we've ever had since I've been here, and you notice the sign is not there for the who knows how manyth time, yet during the hearing, it's represented that the sign was in fact up there. What's the real procedure here? Okay, so I drive by, as I did this week, a property, and I see the sign not there, as happened again this week. What should I do about that? Because if I try to call staff, they got a lot of answering machines over here, and I don't do text, so what would be the procedure when I drive by? Because in the past, and I'm sure everybody's aware of this, I drove by a case, and the sign was there. And I happen to know a person I've known for over 30 years, and I stopped by there and said, hey, have you seen that sign up there lately? And they're like, nah, haven't seen a sign. Now, was that ex parte contact? I asked them for a piece of information to clarify the case for me. Was the sign there or not? And that person says no. I don't know if that's necessarily ex parte contact. I'm trying to find out a piece of information that pertains to the case. A piece of legal information that came through the case.
That's the definition of ex parte communication.
We don't have a discussion about the sign. We just clearly find out, was it or was it not there? Because I don't want to come in here and say it wasn't there when it really was, which was what somebody indicated last time, that it was behind a tree. Okay, well, that's not true. Okay, so where do we draw the line? If we come by a case, it's not properly posted, maybe you go by another day and it's still not, how do they achieve the 10 days posting requirement?
So,
Since it wasn't posted for 10 days.
well, I think I'm gonna start, Mr. Leffel, with the rules for the Board of Adjustment say you can do one cursory drive-by, right? And more than that starts to become ex parte communication. And then I don't know, Frank, if you can back up to the definition of ex parte. Ex parte communication is conversations with others outside of the hearing about the case.
Go forward. Yeah, right there, at the bottom.
So the conversation that you had with the person that you know,
Which I disclosed that in the hearing.
yes. So then when we get to the hearing, I'm going to ask you if you can remain impartial, because you've disclosed to us now that you've had ex parte communication.
Has nothing to do with impartiality. Whether the sign is there or not has no effect on my impartiality
Okay.
of the case. What it really points to is that the sign was not there.
Well, that.
It has nothing to
that-
do with my impartiality on the case. I'm not judging the sign. I'm judging whether the criteria has been met, in fact, to have a hearing, which requires a sign to be posted for 10 days. So when the sign is not posted for 10 days, and I know that, and I know it's not posted for 10 days, you say I can remain impartial when I know?
I didn't say that, sir. I said I'm
Okay.
going to ask you about it, and you can answer.
And if I may add, Board Member Leffel, the proper procedure, if you notice the sign is not there, call the city. Leave a message if you need to, but call the city and we can address the situation. And that will allow us the opportunity to, so we do have an affidavit of posting, and we need to do a little work to that affidavit of posting, but it is a method to verify that the sign was posted, and there's a photograph of it. If you drive by and notice it's not there, call us right away, and we will address that. But I think Ms. Farbs is correct in if you're trying to gather information from a neighbor about whether the sign is posted, you're gathering information on the case, which is something that should not be done outside of the hearing process. So I would say, if you see something like that, call us right away. Leave a message, call me, call Heather, call Quali. We can address that situation before the hearing. And then if there is improper notice, and I'll talk about this in the report outs, but we're gonna try and change the agenda for all the quasi-judicial boards so that they look a little bit more like the council agenda. And there will be an opportunity, instead of opening a public hearing that's been improperly noticed, which we shouldn't do, there'll be an opportunity to approve the agenda. And if we find something like that in advance, we can change the agenda to renotice that particular case. And that'll be a part of the regular agenda to approve, your regular agenda to approve the agenda for the evening. And so we can, that's the point where we would want to, if a case has been improperly noticed, we'd want to change the agenda for the evening so we don't open that public hearing without having proper notice. Does that make sense?
I appreciate that point very much, and I would like to just get perhaps a slight clarification on or we can maybe get the printed copy of the drive-by rules, because that's not the rules that were explained to me 20-some years ago when I joined the board. So I'd like to see the copy where that's written down. It says we can only go by one time and we can't get out. I'd like to see the details of that.
Sure.
That is not what was explained to me.
We can circulate
Be
that.
happy to see it.
Yep, happy to do it.
And Mr. Sutherland, I was wondering, because I understand Mr. Leffel's concern that's concerning for any board member. In our packet, could you include the affidavit in the picture that you take? Because I have not seen them in our staff report, and I think that would just make everyone's like, oh, there's a picture. We see it. Staff went out, it's affidavit signed, and we're happy and hunky-dory and can move along. Could we have that going forward?
So I have talked with the city manager about this, and we are going to include the posting notification as exhibits in the council reports. So I suspect we'll be doing that as well. It may take a little time, but we will get there. We've got sort of a little, we have gone back and forth as staff on this over the years. We used to include the information, but I think it's probably time to start including that again. And what we do for city council, we will do for the boards and commissions.
I was just saying, if we could move on, I know there's only a few minutes left, and Ms. Farbs presented, or has about halfway to go, so don't want to keep her from her
I
presentation.
think
We can keep going.
After?
We don't have to start the regular meeting.
At 7? Okay.
Yeah.
Okay.
Okay, any other questions on this slide? All right, we could move on to, we've got a couple of slides on the hearing. This one is just kind of a inside the box, outside of the box. This slide is just sort of a reminder, your job is to act like a judge, All right, so fairness is important. It's important that you're neutral and that you don't make any prejudicial comments, that you're listening to the testimony, and then you make a determination based on the facts and the evidence that are presented to you during the hearing. I had a really fun conversation with my 8-year-old niece about the difference between a fact and an opinion the other day about strawberries and whether they're delicious or not. And distinguishing fact from opinion, I think, is maybe a little bit more nuanced here. And then this is your chance to ask for clarifying questions, including, what is an extenuating circumstance? What is, how did staff come to make some of the determinations that they did? This is your chance to get answers to all of the questions that you have based on the evidence presented, your review of the packet, and all of those other things. And it's your chance to find facts. Let's see here. Okay, and then we're getting close, folks, I promise. And then you all get to deliberate. And this is your chance to articulate your position to each other. And it's important that you have your discussion and you put that on the record, because this is something that will be evaluated should there be a 106 challenge to your decision. As it says in this bullet point here. Yep. And then here's some tips and tricks for your discussion. Focusing on the issues, and keeping the criteria handy, because that should guide your decision. Including applying the criteria to the evidence that's presented to you. And using that as a way to defend your position, ultimately, and the decision that you make. Okay, here are your three choices, and I know Mike has a lot to say about this next slide. You can approve with conditions, which presents some challenges, as I'm sure you're all well aware. You can deny, or you can continue it for further consideration or action at a future date, which I'm sure you're all well aware. I saw you do it last month. This next slide talks a little bit about the challenges of approving with conditions, which is, can present some challenges. And I will turn over to Mike to talk about that.
I would just implore you, if you want to do conditions, or if you would like to continue a hearing, you should involve the applicant in that decision. In my opinion, the applicant, after making a complete application, has a right to an up or down vote. So if you want to continue it, you should ask the applicant if they are willing to continue and they are available on the date certain that you want to, and you may have to reopen the hearing to ask the applicant these questions. I'll let Ms. Farbs is your legal counsel, and you may need to do that, but you can ask your legal counsel if you need to reopen it to ask the applicant a question. If you have conditions, I would implore you to ask the applicant if those conditions are acceptable. If they are not acceptable for some reason, again, you can do an up or down vote on the application as presented. If staff is recommending conditions, an appropriate question of staff is, has the applicant agreed to these conditions? And if not, we should be pointing that out in the staff report. But I would just ask you in those circumstances to involve the applicant, and that can help make your decision, or help you make a decision at that point.
That being said, you don't have to. You don't have to.
That's why I.
It's your prerogative. You get to make that choice as a body. But it's a good point that Mike makes, that, you know, the chances that the conditions are going to be upheld maybe are more likely if you involve the applicant, but it is your prerogative. You as a body get to make that choice. Conditions can be hard to enforce, particularly if they are not crystal clear. If they're over a long period of time. So be thoughtful about those, I think. Sometimes they're very much appropriate. So keep that in mind, just as you're deliberating and as you're making decisions, that is certainly an option for you.
I have a question.
Yes.
Sorry. Can you give some examples of conditions that we would have included? Generally, my brain goes like, you have a year to get your building permit, or else the variance is null and void. That's what I typically have seen in my career, and it's those type of things. And I don't really think of, well, it has to be purple. You know, like that would be kind of like, okay, we want Barney colors. It's a little hard to enforce, but you know, can you just give a couple examples? Thank you.
In another jurisdiction I worked in, we had about 5 variances a month, and so we had lots of exposure and experience. We did have instances where, in your case of the time frame for the building permit, perhaps the neighbors were saying, we don't want to see construction dragging on, and so the board imposed that condition. And then if the applicant couldn't complete construction, they had to come back to the board to ask for an extension. But in that jurisdiction, all variances were granted for a 1-year time period, so the applicant had to ask for extra time. Another condition could be, and this one is, as we described, hard to enforce. Say there's a hedgerow along a property line that screens the view of a fence or a structure or a shed or something on the property, and you impose a condition that says that hedgerow has to be maintained. Well, 15, 20 years down the road, no one's keeping track of that condition, and if the hedgerow disappears, we have no way to know, oh, that was a Board of Adjustment condition 15 years ago. Does that make sense?
What about hours of operation or something like that? Hours of operation?
Well, you shouldn't be hearing, so the use by permits are going away with the new code. So those kinds of things really are not going to be in your prerogative anymore as soon as we get the legislative zoning done.
I have one. Thank you. On these decisions, as far as the criteria, and for city council, we have a booklet that shows all the criterias. And I know when it comes to board adjustments, there's not that many, but we should have some sort of laminated sheet or something that we can refer to, so when we insert what that criteria is, we have a set of rules right here, so to have to go look for them. Is there any way that could happen?
Yeah, we have notebooks, as you're familiar with, for the city council and the planning commission. We can easily prepare a laminated sheet as you're asking for with the criteria so that you have it handy.
All right,
Thank you for asking.
Yeah, that would help. I appreciate that. Thank you.
Anything else? Okay, we made it to the last slide, which is the one that we want to avoid. Judicial challenges. This is the Colorado Rules of Civil Procedure, Rule 106A4. So anyone challenging a decision that this body makes has 28 days to file an appeal. It's on record, which means the court doesn't hear any new evidence. And the standard that the court will use is on this slide. It's an abuse of discretion by this body if it exceeds your jurisdiction or if it's arbitrary and capricious. These appeals can be very challenging, very expensive for both the person challenging and for the city. They can also be very public. Lots of newspaper articles. And frankly, unnecessary in terms of like how this body operates. If you all are doing your job and you're doing it well, these don't happen very often. I have seen them over my years of practice be also very long, drawn-out battles with regular newspaper articles. And frankly, it is my job to try to keep you all out of the newspaper. That is one of my main goals. So anyway, this slide is here to kind of give you a sense for what happens if we don't operate the way we hope to. I don't know, Mike and Heather, if you have anything else you want to add here.
If there is any type of challenge, we will defend the board vigorously. Of course, any board, any, it's our job to defend it vigorously. But we can make our job a lot easier in some of these cases by following some of these protocols.
I know y'all's tenure with the city is fairly new. It might be a question for Mr. Lovell, but do you know of how many times in Commerce City it's been challenged, the 106s? 2?
If I may, the Board of Adjustment, since my tenure, which nobody seems to really remember when that started, has only been challenged one time by Izzy Sonerick in the case regarding the time to change halfway house. And he lost that case, as I informed him he would before he even brought it. So it's happened one time ever that I'm aware of to the Board of Adjustment specifically, one time ever. Izzy Sonerick would not listen to me, and he lost a lot of money on that deal.
Yeah, this is the final, so the Zoning Board of Adjustment has the final decision.
Your next step's up to Adams County after this.
Yeah, exactly.
I have just to clarify, for arbitrary and capricious, can you define that? I get the other ones, but capricious just is like, I can't come up with what that means right now.
I'd have to go get my Black's Law dictionary to define it for you perfectly, but this is a pretty high standard of disregard for the rules. Arbitrary and capricious is not following the basic requirements. I would say this is if someone were to be arbitrary and capricious, they would have taken a very opinionated stance on a particular case, and complete disregard for any of the rules that and requirements that we've talked about for the last hour or so. Does that kind of give you I can look it up if you want. I can Google.
No, I can Google myself. I was just
Okay.
like curious for, we have hearings today. Oh, that'd be nice to.
Negligence is here, arbitrary and capricious is.
A classic example, without having to define the term, is if you made up your own criteria for review and cited that as the reason for your decision. That would be arbitrary and capricious.
Good example.
I think another area where arbitrary and capricious could come in, and we just talked about this, is when you try to set conditions that haven't been very well thought out ahead of time, just kind of off the cuff of the board. That's where you certainly enter into the arbitrary and capricious realm. That's why we were recommended not to do that.
I think if they were something like you gotta paint your door purple with yellow stripes and.
Definitely falls in that last category.
Yeah, I think that's right. Yeah. Okay, that's the last slide. Do you all have any other questions?
I just wanted to throw out just a couple of bullet points. As we've talked about this evening, staff is a neutral party. We are not subject to the rule of ex parte communication. So when you get your packet, if you have a question, especially if you think it's something that we're going to have to research or look up to be prepared to answer, shoot us an email, as we've asked, so that we can be prepared. We will make it part of the presentation, or we will address your question directly. So I just want to make sure you're clear that you can always contact staff.
And should that be one-on-one contact, like where I'm just emailing you directly?
Yes.
I'm not copying the whole
Please
board?
don't
It's just
copy the
direct.
whole board.
Okay.
Because that is a de facto meeting.
Okay.
So only copy, or do not copy the other board
Just
members.
direct.
And
Direct to
who do we copy? Frank, or who do we speak with? Frank?
Well, you can send that
Staff
to.
planner?
I mean, I'm the lead planner for Board of Adjustment, and you may not know who the case planner is. It's probably more appropriate for you to reach out to me anyway than the case planner. So, yeah, I would ask you to direct those questions to me. If you don't have my email, send it to Frank and he can forward that on to me.
Okay, thanks.
And responses, though, from a question will come back to all of us or presented in the hearing, so it's on the record.
Yes,
Or that we
right.
all have the same information, including the applicant.
Right.
Thank you.
Thank you.
And then the last thing that we wanted to just say is, you know, the chair is here to run the meeting. We provide a script, and that script is there so that we make sure you all stay in line in terms of the protocol, the steps, opening and closing the public hearing. That's why we prepare that script. And so when the chair is reading from the script, she's keeping the meeting on track. And so we just want you all to, you know, respect her position and understand that she is monitoring how the meeting's going. She's going to call on you if you raise your hand to speak. That's all her prerogative. So that's about it.
Thank you.
And I'd just like to say thank you for requesting this session. I hope it was helpful to you, and we are very willing to do any of this in the future if you'd like to discuss particular issues. So thank you so much for requesting this.
Great. And thank you for the presentation and for the board for the great questions.
And just had one more to add, if we could do for the next meeting and beyond, to start using these prompts up here to help out the chair so that she doesn't look around, she can look at just one area to see who has a question. Because when we push this button, request to speak, it shows on her board and she knows exactly who wants to speak, and it's in sync.
Thank you for bringing that up. I know that you've had conversations and we've talked to Chair Hernandez about that. And I think she's very open to utilizing it, but we do need to do what you just did, which is inform the board members, hey, if you want to be in the queue to speak, you need to push the button so that she can see who's in the queue and then call on you.
Okay.
Yes. And then for us to all agree, if, you know, if you guys are okay with that, we may stumble the first few times, but if everybody's in agreement, we'll go that route for it. So if you would like to speak, I haven't really used it, so I guess you just push request to speak. I'll get it in the queue, and then I'll call on those in the queue. And if you don't do it and you want to ask a question, you know, I'll be cognizant of that, but we'll try to start using the queue for each meeting.
Yeah, and that just helps with the applicant too. That way, you have better flow. And as far as communication, sometimes it can be missed, whatever, but still, at least make an attempt. Don't we have to do it tonight, but maybe next time, 15 minutes before the meeting starts, we get together and we can do a practice run? Just a
I don't have
suggestion.
any problems with that as a board. I don't know if my other colleagues have any issues with changing that process of questioning. Board member Poe, Weffel, and Watkins.
You good?
No, I think it helps the chair run the meeting.
Good. Good. All right, great. Thank you. All right, let's see. Okay. So the time is 7:15, and we are now adjourning this study session. Okay. And then Frank, did you want to open?
Do you want to go straight in, or should we take a break?
You need a break, or? I'm good without one, but does anybody need a break? We good to go?
I don't see anybody indicating the need for a break, so you can proceed.
Okay, great. Did you want to open, Frank? Okay. I think Frank's going to open for the broadcast.
So you can go ahead and call the regular meeting to order, Chair.
Okay, we don't need to wait for Frank to do the announcements for the broadcast.
Oh, I'm sorry, Frank, are we broadcasting live?
Yeah, give me just a sec.
Okay, thanks for waiting. I didn't realize he wasn't ready.
Good evening. The time is now 7:17. We will go ahead and get started. When you are speaking, please be sure to unmute your microphone to be heard on the broadcast. The public who did not register in advance can watch the live broadcast on the city's YouTube channel. For live Spanish translation services, please dial 720-386-9023 and use code 104091 *. Para servicios de traducción en español en vivo, por favor marque 720-386-9023 y use el código 104091 *.
Okay, I'd like to call this regular meeting of the Board of Adjustment to order. Will staff please do roll call?
Board Member Leffel. Present. Board Member Poe.
Here.
Board Member Hernandez.
Present?
Board Member Frey Waite.
Present.
Board Member Douglas.
Present.
Chair, you have quorum.
Great, thank you. Okay, will you all please rise and join me in the Pledge of Allegiance? Can I get a motion and a second to approve the June 9th, 2026 meeting minutes?
I will make a motion to approve the June 9th, 2026 meeting minutes.
Thank you. We have a motion by Board Member Frey White and a second by Board Member Leffel. Please open the electronic voting.
I'd like the record to show I'm going to abstain since I wasn't at the meeting.
Thank you. Okay, 4 yeses, 2 no votes. Most, do we have somebody not vote?
They got
S.
Stephanie
Trujillo.
Trujillo on the list there.
Sorry about that, but for Member Poe, I think there's an option to abstain, is it not? Okay. I'm gonna recast the vote.
Okay.
And then Board Member Douglas, are you also abstaining? Oh, thank you.
Okay, we got 4 yeses. Motion passes. Okay, moving on. I will remind the board of the following. Only ask questions and gather facts, but not express opinions or indicate how you will vote. You are not permitted to provide testimony if you wish to participate in the decision. Only rely on facts developed in this hearing and in the record and apply those facts for the criteria in the Land Development Code. Okay, I will invite the city attorney to address this board.
Is there any board member who cannot hear this matter and make a determination fairly and impartially based on the record before you and the facts and evidence as developed at this public hearing? Let the record reflect that no member of the board has shown an inability to be fair and impartial.
I will now open the public hearing on case AV 26-0007, David Valverde, shade structure variance. Staff will present, followed by the applicant. At the conclusion of the presentations, I will open the floor for any questions from the board. Once all questions have been asked, we will open the floor for public comment. We will start with members of the public attending in person before moving on to those attending virtually. With that, I will ask Planner Dalton Guerra to please present this case.
Thank you. Good evening. My name is Dalton Guerra, Senior Planner with the Community Development Department. This is a request for a shade structure, a variance to the size of a shade structure, going to 540 square feet, where the maximum is 200 square feet at 7050 East 75th Place in an R1 zoned property. The structure was constructed in the spring summer of 2023 without a building permit. And our code enforcement team had received complaints about the neighborhood in general, about unpermitted structures. So in their investigation of the neighborhood, they noticed this structure from the street and opened a code violation. Here are some pictures of the structure as it exists today. As of today, staff has received 7 written comments in support of the application, which were included in the packet and also handed out, I believe, prior to this meeting for the additional ones that we received today. Staff's analysis of the approval criteria. For criteria 1, this criteria is really speaking to the hardship and the physical nature of the property and why this variance is necessary. Staff did not find that there is such a characteristic of the property, a physical characteristic or a hardship, being that a 200 square foot maximum of a shade structure could have still been built on this property. And the larger size of the shade structure appears to be unnecessary, and there's no hardship being presented by the property itself. Criteria number 2, being that hardship is not self-imposed. Staff does find that the shade structure was built without a building permit, without proper consultation with the city, and therefore this hardship is self-imposed. The construction of this structure is self-imposed, and there is no hardship being found by staff. So this criteria is also not being met. Criteria 3 speaks to there being no substantial detriment to adjacent properties. Staff did find that in our review and working with other departments that there actually there's no expected detriment to adjacent properties and no negative impact to adjacent properties. So we do find that this criteria is being met. The next 2 criteria, only one of them needs to be met. However, the first one we do not believe is being met, being that the minimum needed is being granted. And in this case, with there being an increase from the 200 square foot maximum to a 540 square foot maximum, That's an increase of 340 square feet, which we do not believe is the minimum needed to enjoy this structure and the amenity that it provides. So we do not believe that this criteria is being met. Second criteria being that the character of the district will not be changed. Staff does find that this is being met. Even though it's a very large structure, it's still within their backyard. It's still meeting the setbacks and other standards that are outlined in the code. So we do believe that this criteria is being met. In conclusion, with the 3 criteria that staff has identified we do not believe are being met, our recommendation is that the Board of Adjustment denies the case AV 26-0007. And with that, I'm available to answer questions. Thank you.
And is the applicant present to present?
Yes, Chair, they are.
Okay. If they'd like to do their presentation, step up to the podium. And if you could state your name and address.
Good evening, Chairwoman Hernandez, Mayor Douglas, and other members of the board. My name is Ryan Skek. I am here speaking on behalf of Carlos Reyna. He is, in this case, he's a homeowner for this property. You need my full address? Yes, your address. 3233 Osage Street, Denver, Colorado, 80211. So again, I'm speaking on behalf of Carlos. He asked me to come because he could not meet at this time because of a prior work obligation, and he didn't want to further the ongoing process any longer, and in respect for your time, I came in to speak on his behalf. David Valverde is also here. He's also the co-owner of the home, and he can answer any questions you may have later on. First, Carlos and David want to acknowledge that they should have obtained a permit before construction began, and they learned a permit. Once they learned the permit was required, they immediately contacted the city and submitted a permit application. During that review, they learned that the structure exceeded the maximum size limit under the Land Development Code, and since then they have cooperated fully with the city staff and have participated in every step of the process in good faith. They're not asking the board to disregard the city's code. They're asking the board to exercise the discretion that exists in situations like this, where applying the code strictly may not advance the purposes the code was designed to protect. The backyard shade structure is located entirely in the rear yard. It is minimally visible from the public street, serves only as a private outdoor gathering space for their family, and has been in no evidence that it negatively affects any neighboring properties or the character of the neighborhood itself. I think the strongest evidence of that is the community's response. The required public notice process gave nearby residents the opportunity to voice support or opposition. In addition, Carlos and David personally reached out to surrounding neighbors, and they've submitted 7 signed letters of support from adjacent property owners. Notification was provided to homes within a 500-foot radius, and they have documented those outreach efforts. Despite those opportunities for public input, there's been no opposition from the neighboring property owners. That doesn't mean the board should decide to base this case basically on a popularity vote, but it is a meaningful evidence that the people most directly affected by the structure do not believe it has any harmful effect on their properties or the neighborhood. Carlos and David also recognize that this mistake by building before obtaining a permit is definitely theirs, and they own that. But from the moment they learned the mistake, they acted responsibly. They came forward voluntarily, submitted a permit application, and participated in this process. And they're asking for approval through the proper legal processes rather than avoiding accountability. The board exists because not every property and not every situation fits nearly within a single numerical standard. We respectfully submit that this is one of those situations. Granting this variance would recognize the unique facts of this case without undermining the purpose of the Land Development Code or creating negative impact on the surrounding neighborhood. This request is not asking the board to excuse a mistake. It is asking the board to determine whether enforcing this particular size limit under these particular facts would produce a better outcome for the community than granting the requested variance. For those reasons, we respectfully ask for you to approve this requested variance. Thank you for your time.
Thank you for the presentation, and thank you, staff, as well, for your presentation. We'll start with any questions for staff. Joe Fry-Waite.
My first question is regarding to the accessory building definition, which I do appreciate that being included. And I just wanted to clarify, does a shade structure have a different maximum than a regular accessory dwelling? The reason why I ask is because shade structure can be an accessory building, but I don't know if there might be a different maximum.
Yeah, thank you for your question. Really appreciate it. And it's a great question. Accessory structures is really just a term that we use to encapsulate all types of different accessory structures that we regulate. So there is no such thing as just a general accessory structure. There's no standards for something like that. Every single structure has to be categorized as either a detached garage, a storage shed, or a shade structure. There's a number of them in our code that we define, actually. So accessory structure is the general term that we use for all those types of structures. And so the standard for a shade structure is a maximum of 200 square feet. A detached garage can be larger depending on the size of the existing home. A storage shed also can only be a maximum of 200 square feet. So there's different standards depending on the use of the structure.
So it is the use that's the determining factor of the size?
That is correct.
Okay, thank you.
Thank you. And Board Member Poe?
Thank you, Madam Chair. Just reading the code, you mentioned the standards and the square footage. If this was a garage and their house is over 860 square feet, they would be able to build an 864 square foot garage, correct?
That's correct.
Detached.
That's correct.
Carports are limited to 400 square feet attached to the building, or is
Correct.
that detached from the building?
Detached carports are not allowed,
Okay,
only attached.
to be attached.
Yep.
And then if this porch was, if it was uncovered, he could pour a slab as big as he wanted out there to put his amenities on it.
Correct. If it was uncovered, it's a different conversation. And then we kind of get into a little more discussion about drainage. So our engineers would have to weigh in on that as well.
Sure.
But you're correct that if it was uncovered, there's a different set of standards.
And if this was a shade structure that was attached to the house, there really isn't no square footage that's mentioned in the code. So if he was to put a lean-to in the backyard, 600 square feet, that would be allowable under the code.
Attached structures typically follow the principal structure setbacks and standards. So in theory, yes, if it was attached, we'd be talking about different standards as well.
Yeah, the attached, it doesn't even speak to the size, if I'm not mistaken. And so he could make it, the area of the covered area could be, just as long as it meets the setbacks, larger than what the house is. Okay. I just wanted to make sure I was clear on this.
Great. Thank you. And Mr. Pry-White?
In the surrounding community, are there other similar shade structures?
Based on just looking at aerials from a staff perspective without going out in the field and looking in every backyard, there are a lot of accessory structures on this street, in this block. What they're used for is difficult to say just from looking at aerial photos. So I wouldn't be able to say with confidence that there are a lot of other shade structures in this neighborhood, but there are a lot of other accessory structures that may or may not have permits, that may or may not be required to get a permit, because our building code does not require permits for structures that are less than 200 square feet.
Can you say that it's less than 200 square feet for an accessory?
That's correct.
But the maximum is 250, so
There's a little gap there between
There's
our
a
building
50
code and our zoning
square
code.
foot gap between needing a permit and not needing a permit.
That's correct.
We are correcting that as we speak.
Okay, I'm like, hang on. Okay, thank you for that.
I'm not showing any other, oh, Mr. Leffel?
Okay, I wanted to kind of go over this. I think we've been over it before, but in the definition analysis on page 10, it says the structure is defined as a shade structure and an accessory structure. So then we go to the accessory structure, and we wonder what the square footage limits are on accessory structures. So if we could come back to the overhead picture that shows the neighborhood there, I'd like to look at a couple things there. Yeah, that's a good one. So we see his shade structure, yet if we go straight effectively south on the picture or down, we see another structure, looks like it's nearly equal in size, that apparently we don't have a problem with that one. So I'm wondering how his structure fell into the gazebos or arbors or pergolas, because it's obviously not one of those. That was pointed out in the last hearing. So it seems like it brings it back up to the accessory building or structure. So how do we determine the square footage that we can have on this structure, given that analysis?
Yes, yeah, thank you for your question, I appreciate it. So as I mentioned earlier, accessory structure is really just a term for the different types of structures that we regulate based on the use of the structure.
Yeah, I heard that.
So in this case, this structure that, I'll go down one slide, looking at pictures of this structure, it fits in the category of a shade structure because it's detached. And it's not being used to store vehicles, it's not a storage shed, it's not enclosed, and therefore staff has fit it into the category of a shade structure, and that is why the size is being regulated the way it is.
So what is the size then of the shade structure?
200 square feet is the maximum.
Okay, but if he parked his car under there, he could have 400 square foot, huh?
If it was built as a garage and got a permit as a garage from our building safety department, yes.
I'm just not sure it's really, I mean, obviously it's a shade structure, but there's many structures in the neighborhood that detach the same size as the one I just pointed out that you moved away from in the screen. Yeah, that one right just south of him. It looks like his garage is every bit as big. Several other structures in the neighborhood that are detached that appear to be quite close to his size as well. I just wonder why we're so interested in this particular one, and it seems like the definition from where we started in the beginning with this has changed somewhat. Seems like he might be allowed up to 400 square foot with this.
Not in the way that staff has defined this structure as a shade structure. The maximum is 200 square feet.
Okay.
Board Member Poe?
Yeah, thank you, Madam Chair. One other question for staff. The Land Development Code, when was it adopted? This
2009. The current version of it was first adopted in 2009.
2009. And we're probably seeing a lot of shade structures, accessory buildings in this area because this was platted and built in the 50s, late 50s, early 60s. And the code may have been different back then, you think?
Yes, sir.
Is that safe to say?
That's a safe assumption that the code was probably a lot different back in the day.
Okay. So because we adopted another code in 2009 for an area that was developed under another code, previous code, it may have created a lot of non-conforming, legal non-conforming uses. Is that fair to say?
That'd be fair to say, yes, sir.
Okay.
However, in this case, the structure was constructed in 2023.
Sure.
So I wouldn't say that that's the case in this situation, that this would be considered legal non-conforming because it was built only 2 years ago.
Yeah, I don't want to gloss over the fact that the applicant should have come in for a permit and to comply with the code. But had it been built prior to 2009, we may not even be here if they went in and got a permit. I mean, I don't know what the requirements were then, but I just know sometimes codes are, they're adopted for the character and integrity of the community. Just sometimes in some of the older parts, it creates a lot of legal non-conforming uses, which is, they can continue to use the property as is, but it just creates a lot of difficulty for staff to administer and things. So, thanks.
Board Member Fry White?
So, Mr. Garrett, I just want to clarify, you mentioned that it was built in 2023, but the report says 2022. I just want to make sure it's clear when on the
I
record.
misspoke. It is 2022. The slideshow is incorrect, and what I just said is incorrect. It was 2022.
All right, thank you.
All right, I'm not showing any additional questions for staff at this time. Are there any questions for the applicant's representative? If the applicant's representative can approach, we have a question from Board Member Fry White. And if you could state your name and address, please.
Yeah, my name is David. Good evening, everybody. My name is David. My address 7050 East 75th Place, Commerce City, A0022.
Thank you. I have two clarifying questions. Can you or do you plan to store a car within the structure? And then what is the main use for the asset? I can see a table, but I just wanted to clarify from you. Thank you.
Well, when I built that, this 2022, I don't know why it's 2023, that's the year when they built that structure. When we built that was in COVID. We were just finishing COVID year. And then we don't have air conditioning in the house. So we use that mainly to be outside with the family and the COVID pandemic. And then since then, we've been using that space with the family. We have like meetings there. But we don't use that often because we're never home. We're always working. And that's one of the main reasons that we build that in the back.
Does the board have any other questions for the applicant? Thank you. Okay. Do any members of the public wish to provide public comments on this case?
Yes, Chair.
Okay, if you could please approach and state your name and address.
My name is Aaron Valtakis. I live at 18180 East 100th Avenue. I just wanted to come up and I'm pretty familiar with this case. Obviously, you know that. And I wanted to make sure that all the stones weren't left unturned. I want to bring the board's attention to section 21-5400, accessory uses and accessory structure table V3, where it lists all the structures. And there's one called a picnic shelter. I think this structure meets the picnic shelter criteria, which is allowed in the R1 district. Also a notation right above the picnic structure, you'll see gazebos, comma, shade structures. So somewhere down the line, this was kicked out because gazebos and shade structures are separate, even though the definition of the shade structure is gazebo, arbors, pergolas. So I just wanted to bring that to the attention, make sure the board looks at that prior to making its decision. Thank you.
Thank you, Mr. Valtakis. Are there any other members of the public who would like to comment?
No, Chair.
Great, thank you. Is there anyone attending virtually tonight who would like to comment?
No, Chair.
Great, thank you. Okay, at this time, I will now close the public hearing for this case. Is there any discussion from the board? Board Member Fry White?
Before we, did you close?
Yes. Did you have another question?
I had a question for staff.
Okay, if we can reopen the hearing.
And technically, you don't have to reopen the hearing to
Okay, 'cause
ask
it's
the
for
question
staff,
of
but-
staff. If it was a question of the applicant, we would
Okay.
have to reopen the public
Okay,
hearing.
thank you.
From what we heard in public comment, I was wondering if staff could answer the question about the picnic structure within the code as a listed accessory item and define that for us?
Yeah,
Because I
absolutely.
can't
Thank you.
see it in the packet. Thank
Sure
you.
thing. So the table that was referenced in the public comment is a land use table more so, where it's defining what structures are allowed in which zoning districts, which doesn't exactly match the bulk standards table, which sets the standards for specific types of accessory structures. So picnic shelter, or I don't know if I'm misspeaking on what the exact term is, but the picnic shelter that was referenced doesn't have separate standards in our bulk standards table. And therefore, staff cannot put it into that category because we would have no way to regulate it. And staff believes that this is a shade structure by definition.
Did you have further questions, Board Member Frywight? Okay. Board Member Leffel?
So do we have a square foot number for picnic shelters?
Thank you for your question. No, sir, we do not have standards for picnic shelters specifically.
Okay.
However- Sorry, go ahead.
Okay, thank you. So we don't have a standard for a picnic shelter. We determined the guy's not parking his garage under there. Looks like he's using it for like family events where they might be eating or something, like a picnic, for instance, he might hold in his backyard. So if he's using it for that, it doesn't look like a storage shed. It isn't piled full of junk like that guy a couple of months ago. Okay, he's just got your kind of stuff you'd have under a picnic shelter. Table, chairs, items such as that. So couldn't it possibly be that this actually is a picnic shelter? Because we know it's not a gazebo. We know it's not an arbor, and it's not a pergola. So it seems as though somewhere in the code there is an allowance for this gentleman to have this. We've just not went there for whatever reason. So I would propose that this is a picnic structure. It seems like he's using it for that, not a storage shed. He ain't working on his car under there. Maybe that's what it actually is. So he would not, in fact, be in variance of any square footage rule at all if we were to perhaps look at it as a picnic structure, which is a permitted use. Thank you.
Mr. Leffel?
Yes.
Just to address and follow up on what Mr. Guerra was explaining, there's not always consistency in the code between different sections. And so what Mr. Guerra was saying is the use table that describes what uses are allowed in what zone district uses the terminology for picnic shelter. There's no parallel in the bulk standard code which identifies what the setbacks are. So there's no way for us to apply specific setbacks to something described as a picnic shelter. That's a disconnect that we have corrected in the new code, and we will no longer have that issue. But for this case, this structure is defined as a shade structure, and the variance you're being asked to consider tonight is related to a shade structure square footage.
Thank you. And Board Member Frywight, you have a question for staff?
So I'm not following. Where is the definition of the picnic structure? Because for the, I thought it was in table 4 and I don't see it in the link. And so I just wanted to read it.
Sure. It's actually found within our land development code. I'm not sure if it actually made it into the packet. Happy to send you a link or provide the materials, but it's in section 21-5400 of our land development code.
Accessory uses and
Accessory
structure.
structures table, correct.
Okay, you have a link to there. All right, thank you.
And so that is where the picnic shelter term is used, not defined, but used.
But used, so, okay.
And as Mrs. Vidlac was saying, the bulk standards table in a further section down in section 21-5450, that term picnic shelter is not used. And so there's a little bit of a disconnect there that we are addressing in the new code. But that's why staff has made the determination that this structure pictured here meets the intent and the design of what we would consider a shade structure by definition.
And where in the table does it say picnic? All I see is shade structures and nightmen's watch quarters, horse and livestock pens. Not seeing.
In the accessory uses table, it's under a subcategory of recreational.
You said,
It's the one that has all the Rs in it.
oh, the link doesn't take me to that one. That's where I'm losing.
Sorry about that.
Okay, thank you. I'm like, where is? Okay, thank you.
Did I answer your question?
Yeah, I was looking in the,
Okay.
the link took me to a different section of the
Yeah, no
code.
worries.
Thank you.
Okay. I don't see any other questions in the queue. Any deliberation from the board you'd like to talk? Oh, you have another question. Board Member Fry White?
Miss Forbes or Mr. Garrett. So I can understand, you know, we have a definition of what a picnic structure is, but the accessory table doesn't have a maximum. And so you guys are, as staff, are, in our professional opinion, we are going to categorize it as that. But it is, a picnic table is defined, it just doesn't have a maximum. Is essentially our code does not have, because there is none. I'm just trying to run this thought down so when we get to deliberation, I have a general thought, because I can understand shade structures here, but in listed definitions, it doesn't have one. So I can understand why putting it into a different box, but it's not the same box from the definition or from what a picnic shelter is.
You're correct. That just one thing I want to clarify is that there is no definition for picnic shelter in our code. It's simply called out as a permitted land use within certain zoning districts.
So it doesn't have a definition anywhere, it just says picnic shelter.
That's correct.
Okay. But in the table, it's still an accessory dwelling. So
It's still a permitted accessory
it's
use.
a permitted use, so therefore, because it's a accessory and, okay, I just wanted to be able to follow where you guys were coming from and how you came to the definition of shade structure, but it's a picnic and that relation.
Yes,
Thank you.
sir.
You're good. Okay. Any deliberation? Oh, Board Member Douglas?
Yes, thank you. Yes, it's just make things kind of difficult since it is in the accessory uses and accessory structures, but it's not identified as far as the size. And the fact that it's within our section 21-5400, it, even though this has been identified as a structure for shelter, but then so is a picnic shelter. So, since we're going through the process of recategorizing things and putting limits on our sizes, minimums and maximums, I think this just clarifies that this could fit into a picnic shelter, but it's not defined anywhere. So if you wanted to put conditions, how does that work?
Is your question related to adding conditions to your decision?
Yes.
I will defer that to leadership over here to my left.
I think the issue here is the terminology and the fact that the code is inconsistent. I'm not sure where you're heading, Board Member Douglas, in terms of imposing a condition. I would suggest that it would not be appropriate for the board to impose a condition that differs from staff's interpretation of this structure. We do really need the board to rely on our interpretation of the code and make your finding based on the facts that are presented tonight.
Okay, all right. Because it was part of the packet, when you go on and you can see descriptions, you can hit on it, and it takes you to this category within our packet. So that's why I'm asking. Okay, thank you.
Thank you, Board Member Douglas. And I believe Board Member Leffel, you have a question for staff?
I don't know if it's necessarily a question, more of an observation. I feel the structure's been misdescribed and that there is a more appropriate description, that of a picnic shelter. Any structure such as this is going to create shade, okay? It doesn't matter if it's 2 foot square or 200 foot square, it's going to make shade, so they're all shade structures. So you've included in a category that would include any structure built. Your garage, it creates shade. Your house creates shade. All these structures create shade underneath them. This looks like they're using it for picnics to me. That's what the table and everything in there. So I feel that this structure has been miscategorized and may not, in fact, be in violation of any code whatsoever, other than the fact he neglected to get a permit. If that's going to be the sole basis, many cases we hear have forgotten their permits. And I don't think we can judge on that alone. So I feel that this is much more of a picnic shelter than anything else. That's it.
Thank you. Board Member Fryway?
So I believe we're in the discussion phase. And I appreciated how staff explained how they got to the shade structure definition. But based on so in the variance approval criteria, we have section A, which has 3 that we have to meet. So in general, I understand what a picnic structure is. It's for sitting outside as described as the use that was described during the hearing from the applicant which is why I asked about what's the main use. Is it outside? And they said outside and visiting. Because there is no regulation or continued furtheration, there is a disconnect. But it is very clear what a shade structure is. I disagree with that there is a maximum for it, but that section A2, the hardship is not self-imposed. And so with that, which is meaning I didn't do this to myself and I pulled the permits in the correct order, the applicant was very clear that they realized they needed to pull a building permit during the hearing. And so I do think from that alone, they have made it very clear that this is self-imposed. And so they're not meeting that one requirement. Where I do think on A1, it is being met because there is no maximum requirement for a picnic shelter within the code itself. But overall, and for the other section, so section 3, I do agree with staff's analysis that it does meet that requirement, and for B2 that it does meet that one as well. But overall, I don't think that based on the testimony of the applicant that we can get around A2.
I would agree with you there. Board Member Poe?
Yeah, I would just like to, I would agree that, there is a it's blatant that they did not get a permit. I would submit to the board, though, that the hardship itself could be the code itself. Because there is inconsistency. It makes it really difficult for staff to make those interpretations, especially a building official. But if they did come in and get this building permit, it's up to the building official to determine what the use is. And it just, because of the inconsistency, that's the reason why staff is doing the right thing and updating our code. I would submit to the board that the hardship is the code itself, unfortunately, because of the inconsistency for that criteria.
Board Member Fry-White?
So, Mr. Poe, just to follow up, I appreciate that thought pattern. And maybe staff can clarify what requires a building permit to need to being pulled for a structure. We talked about you don't need one if it's 200 less for an accessory building, but above that, is there a building code requirement that's needed?
So any, in our current building regulations, any structure over 256 square feet requires a building permit. We are rectifying that with the code so that it will be anything over 200 square feet. This is a structure, so flat work, for example, does not require a building permit, but a deck would require a building permit. So there's some distinctions there. Does that answer your question?
Yes, thank you. And so my question, Mr. Poe, based on that, on the building permit side, does that change your analysis on section A2?
Not really, because if the building official, for whatever reason, does define this as a picnic shelter, there's really doesn't speak to the square footage, which would give him the leeway to issue that permit, if that was his interpretation as a building official. It doesn't speak to that. The code doesn't speak to the square footage if he defined it as a picnic shelter.
Follow up on that?
Can you go through that one more time for me?
Well, if he came in as he should have done in the first place, we all recognize that he should have got a permit. And the building official looked at this and said, hey, this falls under the picnic shelter, which does not really have a requirement for the area or square footage. As building official, sometimes they have that discretion. They would have been able to permit this if that's their finding. I'm not a building official, but I was in a previous life. They would have been able to issue that permit and not, but for whatever reason, because this was done the way it is, they deemed it that they interpreted it as a shade structure, which obviously brings into account the area limitation. But my reasoning is that if it falls under a picnic shelter, the code is moot to that square footage requirement. So in essence, if that was the case, this could have been permitted at that time, in my opinion, but staff may think otherwise.
Go ahead, Board Member Fry-White.
Sorry. Clarification, there is a building board of appeals for building regulations, correct? Because we're looking at zoning code, not the building code.
Right.
So I'm just I want to clarify that.
There is a building board of appeals that is stipulated in the city charter and the city code. Currently, we have 2 members, I believe, appointed, so we don't have a quorum for that board, but there is a building board of appeals. They usually will adjudicate interpretations of the International Building Code and the International Residential Code.
So just to add on to that, what is being considered tonight is a zoning interpretation. And to clarify Mr. Poe's statement, it's actually the planning division that makes the interpretation of which structure this is categorized as, not the chief building official.
Thank you. And I believe Board Member Leffel, do you have a question or further discussion?
Yeah, I don't know if it's a question. It seems as though there's some vagueness regarding what this structure is and how big it could or could not have been. It seems like what it boils down to is this question about not being done with a permit. Okay, well, we're not going to get around that. The guy didn't have a permit when he built it. But I would like to say that if we're going to use that criteria alone and be consistent with future cases, many cases we've heard in the past have not gotten the proper permits, but yet have been approved. This gentleman seems like he has offered to retroactively seek those permits and have the inspections to assure it's safe. So while he didn't do it up front, he's volunteered, I believe, to do it after the fact. He's nodding his head to confirm that. He has volunteered to purchase the permits and go through the inspection procedure for this structure. So really, it all just boils down to he didn't get that permit. Same thing has happened to a lot of other people that have came to this board. We can't really define it. I still feel it was falsely defined in the beginning. And other than the not permit, he should have never been cited in the first place because we can't define it and we don't have a square footage for that definition that we don't have either. So he has done pretty much everything he possibly can do to conform with what the city has requested. We can't go back and fix that permit problem now, but he'll fix it in the future. It'll be inspected. If it don't make the inspection by the building inspector, then he'll have to fix that. So I think we really should move to approve this.
And I think we're looking at this as a unique case, since the other ones weren't meant to set precedent,
Pardon me?
that this is a unique case. We're not looking at the previous cases, that this is a unique case that we're looking at as far as,
I think this case is a unique case. There may have been similar cases, but we're not comparing that. We were just reprimanded on that earlier tonight.
right?
But if we give him the benefit of the doubt, which in my opinion is what this board is for, people may have made a mistake, they may did something wrong, they come here to effectively ask for some sort of remedy or forgiveness. I can't imagine making him tear this down is going to improve the neighborhood. Matter of fact, looks to me like there'll be a number of neighbors probably be angry about that. So I feel we should attempt to work with this applicant. He's shown good faith. We could return the good faith. And as I said before, I would move for approval of this request.
If there's no further discussion, are you wanting to put Board Member Fry-White, you have, oh, sorry, I see that, okay. I'll call you next.
I was going to ask to make a motion with the condition. And the condition that I would be in favor of is to approve the variance, that it meets A1, A2, and 3, and B2, but with the condition that the applicant must obtain a building permit from the city building department. The reason why I put this to my colleagues is this isn't the building permit issue because there is an issue with the zoning code and we are reviewing the zoning issues as the zoning board of appeal, that that's actually a building code issue and a building, not zoning. And so kick it off to the building department and the chief building official, and they can approve or deny it, and it goes on there. But we are looking at the zoning in particular, and there is a discrepancy in the code. I understand the logic of staff of it being a shade structure in their opinion, but there is no maximum for the picnic table in particular.
Just a point of clarification. That condition would be unnecessary because it is already in the requirement of building permit process that the building plans reviewers and inspectors find that the structure does comply to the building code. So it is separate and apart from the zoning regulations. And it is not necessary for you to include that as a condition because we will do that anyway.
And all they're waiting for in the Building Safety Division is the outcome of this case.
And so that's, in my opinion of what we've heard tonight is, I don't see this as necessarily being a zoning matter, it's a building matter. And so if you guys approve it because it meets the building code, that makes sense to me, and that's the condition for my colleagues. I couldn't be in favor of an approval with that condition. If it was just a straight up approval, I have some heartache on without that condition.
So was that your motion?
Did you want to, for the record?
Are you gonna say?
I'll let one of my other colleagues make a motion.
So am I understanding, well, we were just reprimanded about the conditions as well. Your proposal is if he gets the permits, if it passes the building, it's okay. I can work with that.
I think what Heather and Mike were saying is that if you all approve this request, the request for a permit is already in the works. So the last step in that process is your approval. So you don't need to you don't need to impose a condition.
Okay.
I can understand that, but just from
You're just,
my
your comfort level.
My comfort and approval is, I just want to make it very clear that you have to get the building permit. That's what's holding up the issue, and from what I'm hearing from my colleagues, and I can understand, like, if that's the hiccup, okay, get your building permit and your variance is approved. If you can't get the building permit for whatever building regulation requirement, then you can't have the structure.
The variance has to be approved before they can move on to that phase.
Yeah.
And so that's what I'm saying is,
That he just gets it, that's all.
variance is approved with conditions, it just throws it back into the building permit, you approve the building permit, variance meets the condition.
I think there's maybe a little bit of a chicken and an egg, because I think the building permit is gonna say, well, but BOA, we need your approval before we can issue the permit.
Yep. And we're saying
We'll do that.
approved if you approve it.
Right.
So if the building department approves it, the only condition is you guys are fine as a building department with the facility.
Might I suggest that you take a look at the variances requested and consider the strict application of this code, which we have had to struggle with, but, this relates to your questions about shade structures and picnic structures. The strict application of the code, as we have determined, we have to define this as a shade structure, and that has certain requirements about area. So the applicant has requested a variance to that requirement. And might I suggest that you consider the strict application of that and the variance itself, as opposed to putting this on the Building Safety Division to determine whether the variance is acceptable or not. Does that make sense?
No?
No.
I can follow. This one, I understand, it's complicated because it's a picnic structure is how we're seeing it. And I understand where staff is seeing there's no definition for a picnic structure, so therefore we're going to categorize it as a building structure. And maybe I missed this in your interpretation, but is it for all accessory structures? Like in the code, it's very matter-of-factly, no accessory structure, regardless of what category, can be above a certain. Did I miss that?
We have specific categories for accessory structures. Although a picnic shelter is an allowed use, it doesn't have area requirements or setbacks or any other bulk requirements whatsoever. A structure like this, we look at it as it has to have some sort of bulk requirements, and in order to get there, we look at this as a shade structure because that is the strictest application of the code. Is that correct, Mr. Guerra?
Yes, sir. And to address your question, I think even further, I think this is what you're trying to get to was, yes, there's no such thing as an accessory structure in our eyes that doesn't have a maximum square footage. In terms of residential properties, every accessory structure has a limit on its size.
So that's listed, but picnic structures is not listed in the bulk standard, which is, the applicant is essentially saying, staff said, this is the requirement I meet. There's a weird question, which they're asking us to deviate because they don't agree with you, and they're asking us, do we agree with your interpretation of the strict letter of the code or their interpretation of the code? And so, that's what we're being asked. Should they be able to deviate?
The direction we gave the applicant prior to even getting to this point was that this is a shade structure. The maximum size is 200 square feet. They would like to pursue a variance to exceed that to the size that it is here. That's essentially the conversation we had with the applicant before we even got to this hearing, before we even scheduled the hearing.
I was just going to say the facts that have been presented to us, it sounds like what he's saying, just reiterating versus the outside. And then Board Member Poe, I'll give you the floor.
Yeah, I mean, I just want to reiterate that staff's in a difficult position with the interpretation of the code, and again, the reason why they're updating it. But I think there is an appetite here for the Board of Adjustment to approve this variance. I'm going to try to form a motion that I think will, hopefully, it will meet the criteria, and hopefully I can get support from that. But as far, I would move that the Board of Adjustment enter a finding that the requested variance for the property located at 7050 East 75th Place contained in case Alpha Victor 260007 meets the criteria of the Land Development Code, and based upon such finding, approve the variance. And the rationale behind my motion, as far as A1, is the extraordinary situation or condition of the property deems itself based on the code's inconsistency, and also for A2, the hardship is not self-imposed based on also the code and the inconsistency of the code. I think if they would have come in with, I guess I'll just leave that as a motion, put that for second. We could discuss that.
Do we have a second?
Following the rest of the recommendation as criteria?
Yeah, all the other ones are,
Okay, thank you.
yep.
So we have a motion by Board Member Poe. Oh, Board Member Douglas?
So just to be clear, the first motion That was made, there wasn't a second.
No.
So that failed, so we went to another motion, correct? Because there wasn't a second for the
No.
first one?
I don't
did
think
not make the
Mr.
motion.
Fry made a motion. He was just
I
speaking
was having
hypothetically.
deliberation about a possible condition. So the only motion that is on the floor that does not have a second is Mr. Poe's, which is it meets a 1, 2, and 3, as he describes, and then B, not B1, but it does meet B2, correct,
Yeah.
Mr. Poe?
That's correct.
Yes, and that's my understanding. I just want to make sure if you had a motion on the floor, that's all. Okay, I will second that motion. Thank you.
We have a motion by Board Member Poe and a second by Board Member Douglas. Is there any discussion before we vote?
I would just like to point out too, this, again, staff's in a very difficult position, and this is, again, I'm going back to the common sense approach. If this was connected to the house, we wouldn't even be here today. Again, that's another inconsistency with the code, because it doesn't mention any kind of square footage. So that's the reasoning behind my motion, not to overstep the bounds of the code itself, the criteria. So just leave it at that.
Board Member Fry-White?
I can understand, staff's request that we follow, and as we had in our, that we meet the strict letter of the code, but the code is, as you mentioned, the strict interpretation is gray, and so that is what is being asked us today, because it does create some grayness on the hardship section, so I just wanted to mention that.
Thank you. Any further discussion? Good. All right, if we can go ahead and open the electronic voting. We've got 5 yeses, motion passes. Thank you. Okay, we'll go ahead and move on. I will again remind the board of the following: only ask questions and gather facts, but not express opinions or indicate how you will vote. You are not permitted to provide testimony if you wish to participate in the decision. Only rely on facts developed in this hearing and in the record, and apply those facts to the criteria in the Land Development Code. I will invite the city attorney to address the board.
Is there any board member who cannot hear this matter and make a determination fairly and impartially based on the record before you and the facts and evidence as developed at the public hearing? Let the record reflect that no member of the board has shown an inability to be fair and impartial. Thank you.
Thank you. I will now open the public hearing on case AV 26-0008, Laurel Laframboise, ADU variance. Staff will present followed by the applicant. At the conclusion of the presentations, I will open the floor for any questions from the board. Once all questions have been asked, we will open the floor up for public comment. We will start with members of the public attending in person before moving on to those attending virtually. With that, I ask Planner Dalton Guerra to please present this case.
Thank you. Good evening, board. My name is Dalton Guerra, Senior Planner, Commerce City Community Development Department. The request at hand tonight is a variance to increase the allowable height of an existing accessory dwelling unit. Our standard for accessory dwelling units is that the ADU cannot be taller than the existing principal structure. And in this case, they're requesting to go higher than the principal structure, so 12 feet rather than the existing residence height of 8 feet. It is zoned R2. The ADU is a permitted land use within that zoning district. This is an aerial photo. The building to the right with the 6525 on top of it is the existing primary residence. And the building to the left, the smaller building, is the existing accessory dwelling unit. Another site plan describing essentially what I just described. And this is a photo from the street view where you can see that the existing ADU, it's being described in this picture as a garage, but it's their proposed accessory dwelling unit, is taller than the existing house. And it's existed that way. Both these structures were built in 1950 for the primary residence and 1980 for the garage building. So they've been here for quite a while. As of June 29th, staff has received no written comments or phone calls regarding the application. And in staff's analysis of the criteria number 1 being that there's a hardship, some type of physical restraint on the property, and in this case, staff does feel there is one, being the topography of the land, of the property itself. And when these buildings were built, the way the topography works on this property, if you're out there, if you walk the property, it's much higher the further you go back into the lot. So by nature, when the buildings were built, the garage is taller than the existing home. And that is the hardship that staff feels is being met here. It can find here to meet this criteria. Hardship's not self-imposed, very similar to what I just described. The land and the topography of the land itself is not at any fault of the property owner. And so staff does feel that this criteria is also being met. Criteria 3, that there be no substantial detriment to adjacent properties, staff also believes is being met in consulting with our building safety division and other departments and with staff. We feel that this will not have any negative impact on the surrounding properties to approve this variance for the increased height. And then one of these criteria must also be met. And the first one being that the variance granted is the minimum needed. It's an existing structure, and therefore they're not asking for any more height than already exists on the site. So staff does feel that this criteria is being met because they're not requesting any further height than what is already existing. And again, that the character of the district will not be changed by granting the variance. The increased height for this accessory dwelling unit is acceptable by staff standards. ADUs are permitted. They're meeting the other standards that we have outlined for accessory dwelling units as well. So this is the one standard that they need relief from. And so staff does believe this criteria is also being met. Therefore, staff's recommendation to the Board of Adjustment is to approve AV 26-0008 for the increased height. And I'm available to answer questions. Thank you.
Great, thank you. Is the applicant present to present?
Yes, Chair.
Thank you. If you can please come up to the podium, state your name and address, and unmuted.
Hello, I am Colin LaFramboise. I am the property owner for 6525 Alder Street.
And if you'd like to present?
Essentially, this property was bought as a cash sale, as the previous owners couldn't do any developing, and they apparently ran out of money and just slapped a flat roof on the first floor of the original main house. It was originally intended to be a taller building than the garage. It just didn't end up that way, and we inherited that problem. I am currently, I've been sitting on the property for over 5 years myself. I purchased it from my parents, who I helped to purchase it before that. They tried to do development and failed due to various reasons. This is the second attempt, and we are very close. If I can make it past this variance hearing, then I can actually start renovating the garage to make it, get it up to code, and start doing some building on the property, which basically has been a giant empty lot for the past 10 years.
Great, thank you. Thank you for presenting, and thank you, Mr. Guerrero, for presenting as well. All right, so it looks like we have questions for staff. We'll start with Board Member Fry-White.
It's Mr. Garrett?
That's correct.
Okay, I just wanted to make sure I heard that right.
I appreciate that.
So in the background, you know that it was the owner's family then purchased it in 2015. The ADU has been unpermitted since its conversion. I'm not following what you mean by conversion, because is it converted now, or is it currently being used as an ADU?
The specifics of that I would defer to the applicant. However, it's staff's understanding that that building is a garage, and to convert it to an accessory dwelling unit that meets all of our standards, this is one of the criteria, or is one of the standards that must be met. So I'm not sure the specifics of where you're at in the conversion.
What is the question exactly?
So Mr. LaFramboise?
LaFramboise. It's a hard one to say.
Okay. I'm like, tough one. So my question is the garage currently in AD? Are you living in it now, or is it
It was converted to living space when we bought the property. I have not been able to change it. We haven't been able to get permission to do anything to it, so it is still a small, basically, apartment. There's all the, all the amenities of an apartment in the building. It's just not legal.
So no one's living in there now, it's just someone built it and it's like, oh, well.
No, I am actually living there, and I'm renting the main house since that is legal, so it's legal to rent.
Okay. All right, thank you.
Yep.
Does the board have any other questions for staff? We'll start there. Okay, if there's not, how about for the applicant? No questions? All right. Appears there are no questions. Do any members of the public wish to provide public comments on this case?
No, Chair.
Thank you. Is there anyone attending virtually tonight who wishes to provide comments?
No, Chair.
Thank you. Okay, seeing that there were no additional questions, at this time I will now close the public hearing for this case. Is there any discussion from the board? Board Member Leffel?
I'd just like to say that this property is typical of many that were built here in Commerce City in the 50s, where they built the lower part, the basement, with a plan of in the future putting a top on it. There's quite a few of these structures in the city, and some of them got garages too. So it's not really an unusual thing. It was a project that they thought servicemen coming back from the war and stuff would get this started, and they would eventually build the top part. So I think the garage, they're both built at the same time. We didn't have a code about the height of that now, and I think in the report here it said they may finish the house. Is that correct, sir? That's correct. You'll put on the first floor, I guess they would call it, since the basement's there.
The hearing has been closed, so if you have questions
Okay,
for the
sorry.
applicant, I could reopen the hearing. Okay, so-
I just was referencing what it said in the report. It seemed as though he's interested in completing that house.
Okay, did you want to ask additional questions? I could reopen the hearing.
No, I don't really have any questions for him. I just was referencing that it said in the packet that he was going to complete that house. So it looks to me like everything's in order on this case. He's going to comply, and he certainly can't help what was done 70 years ago. But it's not a unique case. There are other basement houses here in the city still today. That was just my point. This is not a unique problem right here. Thank you.
Thank you. Board Member Fry-White, did you have a question? You want to make a motion?
I move that the Board of Adjustment enter finding that the requested variance for the property located at 6525 Owl Street contained in case AV 26-8 meets criteria A1, 2, 3, B1, and B2 as presented by staff, and approve the variance.
Do we have a second?
I'll second that.
Okay, we have a motion by Board Member Fry-White and a second by Board Member Leffel. Is there any discussion? There's no discussion, so if we can go ahead and open the electronic voting. We've got 5 yeses, motion passes. Thank you. Okay, is there any board business to discuss at this time? Board Member Fry-White?
I wanted to thank staff so much for the training. I love those, especially since we are a quasi-judicial board. It's very important that we get reminded quite repeatedly, and I appreciate the comments during our deliberation this evening, and it's very much appreciated. I know my colleagues appreciate that as well. For a future training, as you mentioned that earlier in the session, is we are currently operating under the 22 land development code, and we are now going to, what
2009.
2009, sorry, bunch of years. The 2009 code, and now we're moving to a new one. I was wondering if staff could please walk through big changes to that. And then also, it's been mentioned numerous times that there are certain things that we are no longer hearing. And if at that training, you could walk through, did variance requirements change from what we're used to? What considerations, why they were made? Because I believe we weren't, and maybe it happened before me, but I don't recall any conversations of asking for our opinion on that requirement. And so it would be just kind of helpful for that context so that we can uphold the new code more cleanly. Thank you. That's all my comments.
Thank you, Mr. Fry. Wait, so we did do a training session when Mr. Elliot Schaefer was still the Assistant City Attorney on the criteria, but I'm glad you brought it up because we actually have a bundle of code amendments. So of course, you adopt the code in 2025 and then immediately you find things that you want to change. So Mr. Guerra is actually assembling all those code updates, and we will be bringing that forward to Planning Commission and Council later this fall. One of the things that we would like to have a work session with the board on is about the criteria. And it is a pretty high bar right now because you have to meet every one of the 8 criteria. And we would like to talk to you about whether you would want to make changes to perhaps say, maybe some of those criteria have to be met, but others don't have to be met, just so that the bar is not quite so high. Especially if a structure is built without a permit and it's a self-created hardship, it's very difficult for you to make that finding on that criteria. And so appreciate you bringing that up, and we would like to get that work session scheduled so that we can feather in any changes to the criteria along with the bundle of code amendments that we're preparing.
Thank you. And Board Member Poe?
Yeah, I'd also like to extend my appreciation for that training and refresher. I know a lot of work went into that, and it's always good to get the reminders of what our duties are. And I'd also just like to thank you for your professionalism. I know you have to, that bar, Ms. Vidlac, is obviously very high, and it is difficult, but the professionalism of staff to make those determinations and their interpretations of the code is sometimes difficult. I lived in that world here at the city once before, and I just wanted to thank you for giving that information and the due diligence that you guys did on that case. Thank you.
And to reiterate, I also am thankful for the support, and I know all the efforts that go on behind the scenes before we get here. So very appreciative to staff, and to Ms. Barbs, thank you so much as well for taking the time to build the presentation. I know building slides and putting all that is very time consuming, and spending it here to go through it with us, it's really appreciated, and helping us kind of get our cohesion going and to be a stronger board and to be applying things the way we should and making sure we're all on the same page. And Board Member Douglas, thank you for the suggestion for this. I might fumble a little bit, and I'm trying to stay focused. So new tool here, but I think it'll be helpful, and it's gonna, moving forward, we'll continue using it. And I see that you would like to speak, so I'll pass it over to you.
Thank you. No, I appreciate the city staff and the legal side. This is tough, because this is the last effort a resident of our business can make to come here and ask us to look and approve based on the facts and findings, and tonight was difficult. There's a lot to look at and determine, and we had to think outside the box. And we just had a board workshop before that spells things out with certain criterias and conditions. So this was this was a test based on our board workshop. So I appreciate everybody's input. It's nice to hear other board members' thoughts. I said a different capacity, and so I do appreciate everybody's participation in bringing your knowledge and what you would like to see, because we all don't see things the same. Looking forward to the new criterias of what we can and can't do as well, because it is hard based on what the staff has went through for us to have the ability to approve, but we have to see the facts and findings to see if we see if that's correct or not. And very interesting. So don't want to take too much time, but I do appreciate everybody, because you guys this is a long day for you. You just didn't show up at 6. You showed up much earlier than that. Okay? So with that, I will stop and turn it over to the chair. So thank you.
Yep, and Board Member Fry-White, other comments?
I had one more comment. I appreciate my colleagues. I feel like over the last 2 years, we are getting quite cohesive on these things. I know, and I agree with your comment, but this is how the system works, and sometimes it gets a little muddy. But this is what democracy looks like in action, and it is our 250th anniversary of our nation of proving that democracy works. And so these are our tough conversations, and we need our staff in order to defend what the planning commission and the legislation is, and then we as representatives of the people on this board are adjudicating from that. So I think this is like the case that can showcase how the system works. So I wanted to make that comment. I'm sorry.
I guess, and in that spirit, it's a community for a lifetime, so I think of that as well, with all this in the background, so yes, thank you. And it looks like there's no additional questions or comments for board discussion, so I'll move on to, is there any attorney business at this time?
No additional business for the attorney. Just thank you so much for your great participation during the study session earlier today, and for all of your work.
Thank you. Is there any staff business to discuss at this time?
Yes, Mr. Magdalena, would you please bring up the draft agenda? I apologize, this is a planning commission agenda, but as I mentioned earlier, we'd like to align the agendas for all of these quasi-judicial boards with a little closer with what council does. And this is not very different from your current agenda, but there are a couple little pieces that I wanted to highlight. So the zoning board of adjustment is a little different than council in item number 3, but we would like you to approve the agenda for the evening, and I've talked about that in the study session. But you also have to approve your minutes. So council doesn't typically approve their minutes, but a slight difference there. And then we already implemented the query from the city attorney in this meeting, but we'll have that as a regular portion and try and align that with what council does. And then really the items 6 and 7 are slightly differently worded than what you're doing right now. But I suspect that this is kind of similar to what has happened tonight. Just wanted to make you aware of these slight changes, and we're going to implement those next month. And as Board Member Douglas mentioned, we're going to try and work on the public notice a piece of your packet. That will be forthcoming. I'm not sure we'll have that ready next month, but we're going to follow council direction there. And I suspect that we'll be including those with your packet. And hopefully can kind of wrap our arms a little bit more around the public notice requirements and make sure everybody's comfortable with what has occurred with public notifications. So I said I'd be brief. We're going to implement that next month, and appreciate your support in doing that. So with that, I didn't have any other notifications.
Just a quick question for going back to number 3, if we're going to be approving the agenda on the off chance that there was an amendment, would that require an approval as well? If for some reason we had to approve, since we're approving and,
Yes, if you had any type of amendments to the agenda, any changes in order of cases or anything like that, it would require a vote. And if there were an item that was improperly noticed, we would address it at that time.
great, thank you.
Thank you.
And Board Member Fairwhite, you have a question?
So with those changes, we just recently did our bylaws, and I can't recall if we have that order written in there. And so I just wanted to, and I don't have them in front of me, but I just wanted to, if those do come, maybe there might be a conflict there. So if staff could look at those and just verify before our next meeting.
Yes, we can review the bylaws and make sure. Thank you.
Thank you. And Board Member Douglas?
Thank you. Thank you for this change. You know, under the council agenda, approval of the minutes are on their consent agenda. So I don't know if we wanted to make that a consent item.
Appreciate that. We will look into that and try and do it the way council does it. But we typically don't have a consent agenda with the boards and commissions. This is sort of one step in the process, and we may get to that, but right now we don't have consent items within these boards and commissions. So
Okay.
appreciate that.
Thank you.
We have no other folks in the queue to speak, so the time is 8:47 and the regular meeting is adjourned.